It's 12 o'clock. I'm going to go ahead and get started. My name is Dan Quigley. I am the Senior Vice President for Kirkpatrick Management Company. My job is I run the association division, as far as the accounting, the customer service reps, the managers, things like that. So I am in charge of your guys' people who you work with day to day. If there's problems, things like that you can't get answered, I do want you to reach out to me. I think your first line of defense is going to be your manager. Everybody's got a manager. Everybody knows who their manager is. They all have a boss, which is a regional manager. But let me give you my phone number. I'm going to give you my cell number. If there's a problem that you can't get answered and you need it answered, I would like you to call me because you guys pay for my cell phone. Let's just be honest. It's your phone as much as it's my phone. So my phone number is 317-847-0016. Once again, my name is Dan Quigley. I'm the Senior Vice President. Joining us today also from Kirkpatrick Management Company are the people who produce this whole thing and get this going, which is Alyssa Shore from marketing, Kelly Soto, who is the head of customer care. She's the one who talks to most of the board presidents that are on here. They've talked to you for one reason or another, but they're the ones organizing the education this year. It's going very well. There's some roundtables out there. There's more education. But it seems to be working out very well, and we're happy with what's going on. I'm going to start with a couple different things. One thing to pat ourselves on the back, Kirkpatrick did get for the 6th year in a row, did get a top workplace in Indiana. That's important to us just because this is not the happiest business to be in. As far as we get a lot of complaints, we talk to people and nobody ever calls us up and said, thanks for that trash can letter. That was really great of you to send me that. Good picture of the front of my house. So no, we try to make it not easy for people to work here, but we don't want it to be a work camp. So we're happy that we're able to do that. We're proud of that. 6 years in a row. Just a couple stats to get us started, but just to talk about HOAs and condos in general, and Stephen's on here. He's going to talk about a lot of the legal things. But in 1970, there were only 10,000 HOAs in the United States, and right now there are 370,000 HOAs in the United States. 74 million people live in an HOA. And that's basically 35.6% of America live in HOA. So that's a big chunk of people. In Indiana, we have 5,000 HOAs, and it's really not as many as you would think. It's only 12.6% of the state is in an HOA. It's about 840,000 people. So we appreciate what you guys do every day. You are you all are volunteers. It's hard for you guys to walk your dog. It's hard for you guys to go to the mailbox. Somebody's always asking you a question, doing different things. And we're hopefully we're good business partners with you, and that we are helping you do your day-to-day business and manage your property. With us today to talk, and he's going to talk about a lot of the legal aspects, a lot of the documents, and how to read the documents, how to amend the documents, how to, what's important, what's not. Stephen Donham is here from Thrasher Buschmann Voelkel. Stephen did his undergraduate work at Illinois Wesleyan, and he is a graduate of Indiana School of Law. He's been with Thrasher Buschmann for 14 years. The cool thing is he kind of started there as a law clerk and has moved his way up. And he deals with a lot of people know him already, have worked with him already. But Thrasher Buschmann and Voelkel has really been working as a good business partner with a lot of you guys for a long time. And Stephen volunteered his time to come on here and talk a little bit to us. What we're going to do, he's going to have a lot of information. He's going to probably take us up to the 1 o'clock hour. We will have questions after that. And if you want to put some questions in the little chat box down there at the bottom, if it's something that I think I can interrupt Stephen and we can get a good, easy answer out of him, we'll do that. Otherwise, we'll ask questions at the end. You really can't get too specific with him because he's not going to know every neighborhood's governing documents. It's going to be kind of general questions. Hey, what do I do about this? Or, where can I find this? But if you've got questions, put them in the chat box, and he's going to be your guy. What we'll do afterwards is, tomorrow, from Diane Arnett, who's our superstar who puts out all this information, she is going to get you guys the information back as far as you'll get a Zoom link again of this presentation if you want to share it with your homeowners, or not your homeowners, your board. But also there'll be the chat questions will be in there. If we got some questions that are not answered, Stephen will do his best to answer those today, and we'll try and get them to you tomorrow. If we don't get it Friday, we'll get it Monday to you all, so that you can have that. Without anything further, I am going to turn this over to Stephen Donham and let him do his thing. Thank you, Stephen.
Thanks, Dan. Hey, everybody, I'm Steve Donham. Appreciate you having me on here. I recognize a lot of names in the chat. For those of you that I haven't met before, glad to meet you for the first time, though perhaps not face to face. Anyway, over the last 14 years, I've been practicing in community association law. That's not all that we do at my firm, but it's certainly a big chunk of it. I practice in that area along with some of my colleagues. But let's just jump into it. I'm going to share my screen, which allegedly will still work since we practiced that earlier. So let's go. I think everyone can see this.
It looks good.
Great, thanks, Dan. So I'm presenting today on how to read your governing documents. Let me minimize a window here. How to read your governing documents and amendments. So let's get into it. What are governing documents? You might be surprised to know that is a defined term under Indiana law. I've cited here Indiana Code 32-25.5-2-3. Whenever you see 32-25.5, that will tell you we're talking about the HOA code found in the Indiana set of statutes, a state statute that governs homeowners associations. And it says in that particular code section, governing documents include the following: the articles of incorporation and bylaws of a homeowners association, and all adopted amendments of the articles of incorporation and bylaws. And we're going to talk about those a little bit later. And it also says that the governing documents include any applicable covenants filed with the Office of the County Recorder, also, your plat is going to be considered part of your governing documents as well, and I'll talk about those items a little bit later. But I wanted you to know that governing documents is a term of art in Indiana law that governs homeowners associations. And so here's sort of a different viewpoint of what we're talking about. So you've got a declaration. Most of you likely will have a declaration of covenants, also known as CC&Rs. And what CC&R stands for is covenants, conditions, and restrictions. I prefer the term declaration. Others prefer the term CC&Rs. We're basically referring to the title of the document that is recorded with the county recorder's office. And so in addition to that document, you've got amendments to your declaration. You also have a separate document called Articles of Incorporation. You'll have amendments to those as well, or you may have amendments to those as well. You've got bylaws. You may have amendments to your bylaws, plats, amendments to your plats potentially. I put rules with a question mark. We're going to talk a little bit about rules later on. You might have board adopted rules. You may not. Likely your governing documents allow for the board of directors to adopt rules without member input. And like I said, we're going to talk in detail about each one of these. And then if we have time for it, I want to address zoning commitments. That's kind of an issue that a lot of board members don't know is out there. So if we have time, we'll get there. Let's talk first about the declaration. I think the best way to think about this document is this is your constitution. This is the lifeblood for your entire community. And this is recorded against the land with the county recorder. And this is what authorizes everything, including the authorization to create a community association. It authorizes membership in that community. It's going to be binding on the present and future owners in your community. It's going to contain a variety of information, but this is the bedrock document. And so when you think about the hierarchy, and I'll get to that in just a little bit, this is the principal document. This is top of the food chain, if you will. So what's contained in your declaration? Oftentimes, it'll start with sort of a preamble as far as how the developer got here, as far as developing this particular subdivision. But then it'll have a definition section very early on in the document. And this is important because the definitions really help you with interpreting what your governing documents mean. So I want to give you an example. Let's say that virtually all governing documents are going to define what an owner is in your community. And let's say oftentimes I get a question about, okay, somebody bought one of the lots on land contract. Are they an owner? And why is this important? Well, owners usually are also members. And so if someone bought on land contract, are they a member that has voting rights? That's an important question. Can they attend the annual meeting? Can they cast a vote? And so you want to look at your definition of owner to know, does that include land contract purchasers or not? So definitions are clearly very important. Your declaration of covenants will also include maintenance responsibilities. This is a big ticket item in terms of interpretation questions that I get a lot. Is the association responsible for a particular item, or is the individual owner responsible? Insurance obligations clearly are very important as well. Again, there's often a dichotomy between, is the association responsible for insuring a particular item, or is the owner responsible? You're going to find land restrictions. What can I and can I not do with my lot? Those are going to be found in your declaration as well. And then amendment procedures. How can we change the declaration? And we'll talk about that a little bit later on in this presentation. I point out a couple principles from an Indiana Court of Appeals case from 2004, but this is long-standing Indiana law. It says restrictive covenants are a form of express contract recognized under the law. What you'll see throughout this presentation is that your governing documents are considered a contract between the association and the members. So contract interpretation rules are going to apply, and courts will look at these things and apply basic contract principles when trying to interpret them. The other quote that I think is really important is this other one. It says, restrictive covenants are generally disfavored in the law and will be strictly construed by the courts, which resolve all doubts in favor of the free use of property and against restrictions. The way I like to summarize this point is that if court finds that there's any ambiguity in your governing documents, the tie goes to the landowner. So if the association is trying to enforce a covenant against a landowner and a court finds that that covenant is ambiguous, the landowner is going to win that argument. So it's important to be very clear in your governing documents to avoid the tie running in favor of the landowner when you're trying to enforce something. And one of the examples I like is a lot of covenants or declarations will include something about owners shall not create nuisances in the community. And those are difficult cases because a court might disagree with, well, what is a nuisance? You know, if a particular board felt like lawn ornaments are a nuisance, I don't know that every court's going to agree with that. So it's important, if you have a nuisance covenant, you might consider some kind of an amendment to explain, what do we mean by that? What are examples of nuisances, so that a court has some criteria to look at when trying to evaluate whether to enforce that covenant or not. So your next document in the hierarchy is your articles of incorporation. Previously, I talked about the declaration. I like to think of that in terms of that's the what we're regulating in a community. Articles of incorporation are more of the how. How do we regulate? What's the process for regulating? And the articles of incorporation, and that goes as well with the bylaws, which I'll talk about in a little bit. The articles of incorporation, they're not recorded with the county recorder. Instead, they're filed with the Indiana Secretary of State, and they're the documents that set up the corporate entity. So I listed a website here. It's very easy to go on this website. If you cannot locate your articles of incorporation, you can go on that website and go straight to the document on file with the Indiana Secretary of State. You can obtain certified copies of it for free. And oftentimes, I skipped ahead. Oftentimes, I'll even just go straight to the Indiana Secretary of State to make sure that I'm looking at the exact document on file with them. And as I mentioned before with the declaration, here's another case citation that says basically articles of incorporation also constitute a contract. So again, contract interpretation rules are going to apply. And as I mentioned before, these regulate the corporate entity. This is the how, not the what. This is how we govern in this community. So I just wanted to point out some of what the required contents are for your articles of incorporation. There's not a lot that's required under Indiana law. You'll see some citations here. I mean, of course, you're going to have the corporate name has to be included. You'll see a citation here to 23-17. Anytime you see 23-17, I'm referring to the Indiana Nonprofit Code. Most of your governing documents are going to say that your entity shall be an Indiana nonprofit corporation. So that means the nonprofit code will apply, and that means that oftentimes you'll want to look at that particular part of the code when dealing with certain aspects as far as how your community operates. The rest of this information, again, there's just not a lot that has to go in your articles of incorporation. I put down here, avoid overlap. And the reason I did that is a lot of times I'll see articles of incorporation or bylaws talk about assessments, and then your declaration talks about assessments. And there's some overlap with how we go about assessing folks for HOA dues. And the concern is that we run into some inconsistencies. And so in my view, keeping the articles of incorporation as trimmed down as possible is the way to go. Lastly, bylaws, they're sort of third in line. I point out another section of the Indiana Nonprofit Code that says the incorporators or board of directors of a corporation shall adopt bylaws for the corporation. When you see shall, that means must. It's not may, it's not could, it's not should, it is a must. So I've seen courts that if a corporation does not, if an HOA does not have bylaws, that can be problematic. So you need to have bylaws. And I point out this other section of the nonprofit code because this is where we get into some of the hierarchy. And under the nonprofit code, it says your articles of incorporation are going to control over the bylaws. The bylaws, they can contain any provision that's not inconsistent with the articles. And so at the bottom here, you'll see I sort of show you the hierarchy. So your declaration and plats are top of the food chain, then your articles of incorporation, then bylaws, and then your board rules or resolutions. Again, the bylaws likewise are going to constitute a contract between the corporation and its members. This is longstanding Indiana law. And again, these regulate the corporate entity. This is the how, not the what, the how. I thought it's important to talk about where do we find the bylaws, because unlike the declaration, which is recorded, it's a public record with the county recorder's office, unlike the articles of incorporation, which are on file with the Secretary of State, bylaws aren't necessarily anything of public record. The only exception to that, I would say, is for condos, the bylaws must be recorded with the declaration, and that comes from an Indiana code section. And I listed it here, and I just wanted to point out, whenever you see 32-25, we're talking about the condo statute. All other community associations, it's unlikely that your bylaws are going to be recorded on file with the Indiana Secretary of State. So it's very important to maintain good record keeping habits. Oftentimes I find bylaws that are unsigned, they're undated, and it's hard for any current secretary of your corporation to confirm, yeah, these are the bylaws of our association. I know they were adopted on this date. So it's important to take a look at that and make sure that everything is in order, particularly with your bylaws. As far as the contents of your bylaws, you're going to see information about how we conduct meetings, not just annual and special membership meetings, but also board of director meetings. You'll have information about quorum, which is basically the number of members required in order to call a membership meeting to order. If you don't have quorum, which I know many of you experience because of low turnout, it can be hard to even have an official membership meeting. There's going to be information in your bylaws about providing notice, about elections, about who can serve on a board of directors, who are the officers, what do they do, record keeping, and also how do we amend bylaws, which could be a very different standard from how to amend your declaration of covenants. So I know all of you, I believe all of you are already on your board. Many of you I know have served on your board for a long time. So this may not really apply to you, though perhaps some of it does. I always think if someone is recently joining the board, the first step is read or reread the governing documents. And I know that can be a lot of pages to get through, but I think it's important to understand the terminology used, make sure you have a complete version of it, look for things that are contradictory. And whenever I have a new client come on board, I'll reread them, or well, I'll read them, and I'll tab some of the key provisions. And some of them you're going to focus on quite often, whereas others maybe never. I like to tab meeting notice requirements, quorum requirements, election procedures, amendment procedures. Assessments clearly are going to be very, very useful, and you're going to rely on that a lot. Land restrictions, there's other provisions that you'll find in your governing documents that might deal with developer rights. And if the developer is long gone and has turned over the community to your board, those provisions are largely obsolete. You may never really need to rely on those at all. And the other thing I would suggest, and even if you've been on your board for a long time, I think maybe annually it's good to double check your governing documents and at least skim through them to make sure that you're still familiar with them. But another thing I'd think about is reviewing the forms that have been built from your governing documents. A lot of times I'll see architectural request forms that don't really match up well with what the architectural review board's authority is. And that authority would come from your declaration of covenants. So I think it's always good to look at your forms and make sure, have we been doing this right? Perhaps not, and that's okay. Let's fix it and do things right going forward.
Stephen, I have to jump in here real quick. One question.
Yeah,
One thing,
sure.
I told everybody to put their questions in the chat, and I forgot that that's wrong. It has to go. It goes. There's a little button down there that says Q&A. So if you wanted to ask a question, put it in there under Q&A, and not in the chat. That's my. I forgot the chat is closed. They open up the Q&A. So go ahead. Sorry, Stephen. Thank you.
Oh, great. Thanks, Dan. So I want to get into some of the basics of contract interpretation, and you'll see the top of my screen here. It says the canons of contract interpretation. I did my presentation. I practiced it with my wife last night, and she said, I don't know what canons means in this context, so you better explain that. So really what I'm talking about, this is just a fancy legal word for guidelines of contract interpretation. And one of those is the ordinary meaning guideline. And this says words are to be understood in their ordinary everyday meanings unless the context indicates otherwise. So let me give you an example here of what I'm talking about. Let's say in your declaration, you have a provision that says outbuildings are prohibited. Governing documents do not define outbuilding. So what a court would do is say, okay, well, what's the ordinary everyday meaning of outbuilding? Because there's no other context to indicate anything other than an ordinary everyday meaning. And so here I pulled a basic dictionary definition. It says a building such as a stable or woodshed, separate from but accessory to a main house. In my second example here, let's say your governing documents say, again, outbuildings are prohibited, but then there's more context. It says outbuildings shall mean buildings whose primary purpose is storage of personal property. So here we have more context, and let's apply that now. So let's say an owner seeks approval for a greenhouse. I think under the first example, this is a very broad definition of outbuilding where it's just a separate accessory structure. I think a greenhouse probably would fit under the definition of outbuilding and be prohibited under example 1. Under example 2, though, we have more context. We see outbuildings are the primary purpose is storage of personal property. I don't think that the primary purpose of a greenhouse is to store personal property. So here we have a divergent conclusion based on this ordinary meaning guideline. A tool shed, I think probably that would fit under either definition. Clearly under number 1, we have a very broad definition of outbuilding. Under 2, even with this added context, a tool shed's primary purpose is storage of personal property. Detached garage may be a little more questionable under example 2, because the primary purpose of a detached garage probably is to park a car. That's personal property. So even in that context, a detached garage might be considered a prohibited outbuilding in either example. Let's try another canon or guideline of contract interpretation. So fixed meaning, this is another one. Words must be given the meaning they had when the text was adopted. So let me give you another example. And I think solar energy systems come to mind. Let's say that your declaration prohibits solar energy systems and your declaration was recorded in the 1980s. Well, does that apply to newer technology? I'm familiar with solar roof tiles. I believe that's a newer technology. I'm not sure if it's even been released for use yet. I know it's fairly new, but when your governing documents were recorded, and in our example in the mid 80s, solar roof tiles didn't exist. So if there's a prohibition against solar energy systems, I think one could fairly argue the fixed meaning couldn't have possibly regulated solar roof tiles because those didn't exist in the mid 80s. So that's another thing to keep in mind with the fixed meaning guideline. All right. For those of you who were told there wouldn't be Latin on this, I apologize. Aegisdum generis, I'm sure that I pronounced that wrong, and I'll explain all this, but you know, it's not a pardon me, it's not a physical ailment. It's actually a term of art. Um, I'm not going to walk through the quotations here, but basically it's when you list a few items in your particular covenant, and then you have a catch-all provision. And the issue is, what does that catch-all provision mean, and how is it modified by the specific example? So let's walk through a hypothetical example here. Let's say we have some provision that regulates cars, trucks, motorcycles, and other motor vehicles. The question is, well, what fits under this other motor vehicles catch-all provision? Is it literally any motorized vehicle? Not necessarily, not in when we apply this guideline here. So let's take an airplane example. In my view, an airplane would not be considered an other motor vehicle. So let's say that this is prohibiting the parking of these things on a driveway. Cars, trucks, motorcycles, those are all land vehicles. And so I think a court could easily say other motor vehicles only means other land vehicles. And so an airplane isn't really a land vehicle and probably wouldn't be regulated under that catch-all provision. You know, moped's a closer question. I think it's pretty similar to a motorcycle, so that would probably fit under our catch-all here. Hoverboards, I think, I know I'm being a little flippant or facetious with hoverboards, but I don't think that would fit under other motor vehicles because you don't need a license plate to ride a hoverboard. It's motorized, but you don't need a registration tag. Drones as well. I think this one is a little more real world because I know my mom's complained about drones in her neighborhood. But unlike cars, trucks, and motorcycles, people don't ride on drones. So in my view, it may not be part of your catch-all provision here. So something to keep in mind when you have this kind of a catch-all provision. And again, I just want to remind you, tie goes to the landowner. So if there's a question, landowner's probably going to win that argument. Another guideline is when we have a general term versus a specific term. When a contract contains general and specific provisions relating to the same subject, the specific provision controls. So let's do another example. Let's say you've got in your bylaws a general quorum requirement for your membership meetings, that you've got to have at least 10% of your members there to call your meeting to order. And let's say you want to try to pass a special assessment. Well, let's say your declaration sets quorum at 50% for membership meetings to levy a special assessment. Which controls, the 10% or the 50%? Well, here, this guideline tells us the 50% is going to control because that is specific to levying a special assessment. And that would make sense in this context because a special assessment is probably, it's designed to be harder to pass. So it's going to be harder to get enough folks there to pass your special assessment. And again, these are all hypotheticals. Your governing documents may say something vastly different, but I just want to get you a sense of how does this guideline come into play. Another one is the harmonious reading canon or guideline. Basically, what we're talking about is a court is going to presume that when it's got two provisions that seem to be in conflict, the court's going to presume that they can be harmonized and strive to harmonize them rather than strive to find disagreement among those two provisions. So here's another example. And I've seen this before where a developer is just a little sloppy with their governing documents when they put them together initially. Let's say your bylaws refers to the community association as, quote, the corporation, but then your declaration refers to the community association as the association. A court's not going to look at these two provisions and say, oh, they must have meant there's two different entities. There's one entity that enforces the declaration and a totally separate entity known as the corporation that handles all bylaw governance. No, in fact, I think a court's going to harmonize this and say, no, we mean the same thing here. The context clearly means we just mean one entity, one homeowners association to deal with declaration and bylaw enforcement, governance, etc. This is a little harder example. I thought it was useful, especially when you get into trying to amend your declaration. There's a lot of text on this screen, and I know some of these provisions can be quite daunting when you're looking at them, trying to understand, okay, what does this really mean here? I bolded a couple sections, and I just wanted to walk through this. So here at the top, it talks about we need 90% of the owners and the mortgagees, the lenders, to vote to terminate our amended and restated declaration in this example. But down here, it says that to amend the declaration, you need the approval of a majority of the owners. So what controls here? We've got a 90% standard up here, and we've got a majority standard down here. Well, we can harmonize this. Here, we're specifically talking about terminating the declaration, so getting rid of it entirely. Down here, we're just talking about changing it. Not getting rid of it, we're amending, we're just changing it. And so that's how we would harmonize this. We've got a 90% standard to get rid of the whole thing, which it ought to be hard to terminate the entirety of your declaration. Whereas down here, we're just making some tweaks. We just have a majority standard down here. The surplusage canon. Here, we're just keep skipping ahead. Sorry about that, everybody. So this is a quote from an Indiana Court of Appeals case from 2012. We attempt to construe contractual provisions so as not to render any terms ineffective or meaningless. I included a quote here from Yogi Berra where he says, it's deja vu all over again. The reason I thought this was somewhat illustrative is a court looking at that quote would say, okay, we're going to assume that all of these words had some importance here. They're not all redundant. Now, I don't know that a court could find that all of these words are important because it seems very redundant. So I thought it'd be better to use a better example down here. So let's say you've got a quorum standard and your quorum is based on the number of members in attendance, quote, who are eligible to vote, unquote. So if we didn't have this quotation down here, it'd be very easy. Okay, quorum's based on the number of members in attendance. And let's say it's 10%. So you need 10% of your members. Great, we can do that. But we have this added phrase, who are eligible to vote. That has to have some meaning here. And so clearly we'd want to find out, okay, what makes someone ineligible to vote? So you want to look through your governing documents to find out if someone's delinquent on their assessments, are they no longer eligible to vote? Because if that's the case, they don't count towards your quorum. Perhaps they are in violation of some other provision and your governing documents say, if you're in violation of anything, you're not eligible to vote. And so again, any of those ineligible members would not be entitled to count towards your quorum. So again, make sure that you're considering all the language in whatever provision you're looking at, because the court will try not to render any of it meaningless or ineffective. Here's some common issues that I'm asked about. How do we do amendments? Here we have a provision where it talks about, okay, to do an amendment to our declaration, it's got to be approved by a vote of not less than 67%. Great. One thing I'd want to know is, has this provision ever been changed? Has this ever been lowered to 60%, for example? So don't just look at your original declaration. Make sure you're looking at, are there any amendments that's changed any of this information to a different standard? Second is, okay, it tells us we've got to have a vote. Well, how do we conduct a vote? You want to look at not just this provision here, you want to look at your bylaws. That might tell you, how do we vote on matters? How do we vote on our amendments? Perhaps your bylaws will say these votes must take place at a meeting of the members, it must be done by paper ballot. Your bylaws will explain whether proxies are allowed. So it's not just stopping and starting at your amendment provision. You're going to have to look at other parts of your governing documents to make sure you do the amendment process right. It also says here, okay, we need 67% of the homeowners. That's pretty easy if everyone has a one-to-one vote. So all members in your community have the exact same voting power as everyone else. It's pretty easy to do that calculation. Some condominiums, their membership percentages are based on square footage. And so some members may have a smaller, a lesser voting power than others. So you want to look at how do we calculate our percentages to make sure we meet our, in this example, a 67% threshold. And you'll also see here, sometimes with your amendments, it's not enough to get homeowner approval of a certain percentage. You want to have, you'll need to notify lenders if they've provided notice that they're out here to your homeowners association. That can be a little complicated. Oftentimes there is no notice to provide to lenders, but just be cognizant that there can be some additional requirements when you're doing an amendment to your governing documents. Another common issue that I run into is making sure that when we're preparing for our annual meeting and conducting our annual meeting, that we're doing it right. There are numerous provisions in the bylaws that speak to conducting annual meetings properly. There's going to be notice procedures. How many days in advance do we have to send notice for the annual meeting? Oftentimes, it's not going to be okay to send notice 5 days before your annual meeting. And you wouldn't want to do that anyway, because it's hard enough to get quorum. So the more notice you can provide, it's probably the better, so that folks' calendars can remain open for your annual meeting. You'll want to know about how we do proxies in the neighborhood. You'll look to your bylaws for that. There may be a due date that says proxies have to be turned in so many days in advance so that they can be properly corralled, input into your sign-in sheets. Others, however, might say, yeah, just turn in your proxy when you show up and check in. It just depends on what your governing documents say. You'll want to look at your bylaws for how we do nominations. Do nominations all have to be turned in advance? Some governing documents allow for nominations from the floor at the annual meeting, okay, but not all of them do. Some say all nominations must be in 7 days before the meeting takes place. So that's something to keep in mind as you're thinking about what needs to go with our notice packet. It's often not just, oh, here's the date, time, and place. It's, do I have to include the budget with it? And I've talked about that a little bit down here. Do I have to include some financials with my notice packet? Should I include a proxy form? Do I need a nomination form? So there's a lot of different provisions that interrelate in the annual meeting preparation process. And I just made another point down here. I think the articles of incorporation often get overlooked. Always check them, especially when we're talking about procedural issues. There could be something in there that's inconsistent with your bylaws. And if you recall earlier when I did the hierarchy discussion, articles of incorporation, they control when they conflict with your bylaws. So always check them.
Stephen?
Yeah.
Real quick on when you're talking about getting out notice for annual meeting, it's getting to be that time of the year for everything. So a lot of times we will email out those notices, but most of the time those declarations say that they have to be sent out via United States Postal Service, things like that. Is there anything in state law or not-for-profit that says that email is acceptable on that kind of thing? Or so do we still need to make sure that we're mailing all those out also?
Yeah, Dan, the HOA code and the condominium code, they have nothing about that.
Okay.
The nonprofit code, to my recollection, there's nothing specific about how to distribute your notices. So I think your best bet is see if there's anything in your governing documents, particularly your bylaws, that might speak to that issue. Sometimes it specifies. I think clearly if somebody in the community, if the member has said, hey, please email me notices, I think you're really in good shape to email that. Some clearly you're not going to have email addresses for,
Yeah.
and you'll mail those. But
It's
so
not
yeah,
a bad backup, but we should probably still stick with the United States Postal Service just because that's considered If we mail it and we can show where we mailed it, that's considered a notice, correct?
Correct, Dan. Yeah, I think the other thing you could think about is if you do email, I think it comes off perhaps a little rude to ask for like a read receipt on them, but I do know you can do a delivery receipt and know that it made it to that email.
Okay.
Something to think about.
Okay. All right. Thank you. Sorry to interrupt.
Oh, no worries at all. Another common issue in terms of interpretation that I get are maintenance questions. I'm often asked, who's responsible for item X? Is it the association or is it the owner? My question back is often, is this an insurable event or not? Was the damaged item damaged from a hailstorm? If it was damaged in a hailstorm, talking about an insurable event, and then we'll look to the insurance provisions that are likely found in your declaration of covenants for determining, is it the association's insurance that picks this up, or is it the owner's insurance? If it's not an insurable event, it's something that was damaged through normal wear and tear, you're going to have a separate section, most likely in your governing documents, that talks about general maintenance provisions and speaks to, is the association responsible or an individual owner? This question comes up a lot more often in condominiums, and it's important to look at unit boundary definitions, which are likely to be found early on in your declaration of covenants. And the boundaries are going to be very important. And you'll see down here, I list a bunch of things. So drywall is a big ticket item. Do the condominium unit boundaries include the drywall? And if so, we want to look and see, is there a provision that says unit owner is generally responsible for all wear and tear maintenance for their unit? If the drywall is part of their unit, then they're responsible for the drywall. Pipes are another big question, especially in condos. Some governing documents will say the owner is responsible for all pipes serving that unit to the extent those pipes are within the boundaries of their unit. Other documents might say that they're responsible for those exclusive pipes, whether they're inside the unit or not. So pipes are a big item, a big ticket item that requires interpreting various maintenance and unit boundary definitions and provisions within your governing documents. Attics are somewhat similar, where we're looking at boundaries. Windows too, is it just glass only? Is it window frames too? So you can get really granular with some of this stuff when you look at your governing documents to determine, is it the association's responsibility or an owner's? I do want to talk about plats. I thought these are these maps with a bunch of different information that are recorded that some of you, I'm sure, have seen. They are they're on equal footing with the declaration in terms of the hierarchy and are very important. Let's do an example here. Let's say your declaration of covenants, they say no construction of improvements within an easement. Okay. Well, how do we know where the easements are located? Or perhaps you received an architectural request where the requesting owner has plotted their proposed fence in an easement. Well, let's look at our plat and see what it tells us. So we see this DU and SE. That in this context stands for drainage, utility, and sewer easement. So if somebody's plotted a fence back here within this easement and your declaration says absolutely no improvements, including fences, in an easement, there's no discretion for your architectural committee. They cannot approve this. So it's important to know what this information says in your plats. Similarly, here you'll see 20-foot BL. That stands for 20-foot building line. And perhaps you have a provision that, like our easement example, says no building beyond, or no improvements beyond the building line. Your plats may also contain not just this map information, but also their own restrictions. A lot of times I'll see plat restrictions that limit the kinds of vehicles that can be parked in public view. And you might have a similar provision in your declaration. And so you might find some overlap between restrictions on your plats and restrictions found in your declaration of covenants. And if they don't match up, I would argue any ambiguity runs in favor of the landowner. So if one document is a little more restrictive than the other, like I said, plats and declarations are on pretty equal footing. So a landowner might be entitled to the more favorable restriction if there's some overlap between your plats and your declaration. Rulemaking, I think, is really important. Oftentimes, your declaration of covenants, perhaps even your bylaws, will empower the board to pass rules. Okay. The key is to make sure that those rules do not go outside the scope of what that rulemaking authority is. So, give you an example. Earlier this week, my colleagues and I were reviewing some board rules that regulate lawn ornaments. And our question was, well, the only rulemaking provision we could find in that is found in your declaration, in the Declaration of Covenants in this example, pertain to suspension of voting privileges. It had nothing to do with regulating lawn ornaments. So that's not enforceable. We have to be, boards have to be very careful not to go outside of the strict powers they're given to engage in rulemaking, because what the board's basically doing is unilaterally imposing additional restrictions that weren't voted on by members. So it has to be narrowly tailored to what that authority is in your declaration. Another example is if there was a rule that prohibited a delinquent member from running for the board. We better have some rulemaking authority found in your governing documents that allows for that kind of a rule. This was my last topic, and this is, so I think we're doing pretty good on time here. There are things called zoning conditions and commitments, and these are certain promises made by the developer to the county regarding restrictions that will apply to a community. Not all of your communities are going to have any of these, but they might. While zoning commitments are recorded, zoning conditions are not. And so here's an example of why these are important. Let's say that your declaration provides that sheds are prohibited, okay? And let's say that you've got this groundswell of members that say, hey, we want to have sheds in our community. We want to delete this provision. And so you think about trying to pass an amendment to basically delete your shed prohibition. You better look to see if there are any zoning commitments first, because I found an example where I had a community that wanted to basically allow sheds, but their zoning commitment said, no, this community is going to have a shed prohibition. And so it's not just amending your declaration, but in this instance, going to the county to say, hey, can we lift this zoning commitment? Because we want to allow sheds in our community. And these commitments, while they're recorded, they can still be hard to find. Marion County, what I normally do is I'll email the planning office. There's a planner on call that you can email, and I can get a pretty quick response of whether there are any zoning commitments for a particular neighborhood. I suspect some of the donut counties are helpful as well. I just happen to use Marion County more often when I'm trying to determine if there's any zoning commitments out there. Dan, that brings us to about 10 till, maybe 12 till. So time for some questions. Especially if I went through that a little fast.
That's okay. I have a couple questions on here that came through, and I think we'll start. I think Terry Hecht, you have raised your hand, but I'll get back to you in just a second. Let me start with these questions. From Jay Bradley from Hidden Bay. He said they had just talked about being a not-for-profit. However, we were told this summer that HOAs were not for profit by the IRS, but considered a member association. Why is that? And is the difference is why we had to finally pay income taxes? Is that too specific, or is that something you can answer?
Yeah, that might be a little, I might need a little more detail on that one, Dan. You know, I think where I would initially want to look is in our declaration, what are we supposed to be? You know, does it say under our definition of association, this shall be a nonprofit corporation under the laws of the state of Indiana? And then I then go and look at the Secretary of State's website and say, are we or not? Because when that website that I put up before, it will tell you if you're a nonprofit or not. And so we may, in that instance, you may need to change something. You know, as far as IRS issues, I don't get too into the tax return stuff. Most HOAs file I think it's an 1120H form. Probably a better question for an accountant. And Dan, maybe, I don't know if KMC handles that for certain communities and if you can speak to that, but that's a little beyond what I normally do.
So we had there are some higher yielding bank money market accounts that some people got some, they had large reserves, and so they brought in some interest, which pushed them into a profits area. So that was there are some people who had to pay some income taxes this year. But Jay, I'll look into that a little bit later and get back to you off separately then, and get some more information from you on that one. So sorry about that. David Stahl from the Modern asked, you have covered two differences between HOA and COA, and recording how to record, share, or weight of a vote. What other differences can a COA watch for? I think what he's talking about is at an annual meeting, as far as anything specific we need to look for on that.
Yeah, David, that's a good question. In terms of, I'm just reading the question now. I know you read it, Dan. I'm sorry about that. Yeah. Any other main differences? Really, the main differences, David, are just going to come down to maintenance issues. I mean, clearly there's going to be a lot more questions as far as whether the association is responsible for certain items within a building when you've got multiple units versus the unit owner. Because unlike a typical HOA that's a PUD, you've got freestanding homes on an individual lot. Those questions certainly don't arise as much, and those won't have membership interests that are any different than just a 1-to-1 ratio, unlike in a lot of condos where it's based on square footage. So those are kind of the main differences.
So what's the difference between a condo and a PUD or a PUD?
Yeah, a condo is going to be set up under the condo statute and call for percentage interest in the common area. And so what happens is the members within the condo association, they co-own all of the common area according to their percentage interest, unlike in a PUD, for example, where the entity, the homeowners association itself, it owns the common area. That's one of the main differences. Other differences include how maintenance is done. Condos are going to be where the owners basically own this interior white box, and then the association, well, the rest of it is common area that's not considered part of the condominium unit.
Okay. One question. So we're talking a little bit about, 30-day notice, 20-day notice, different things. If we miss a 30-day notice and we end up getting everything on 20 days, is that the end of the world? Do we need to start all over again? Or what legally would you give us as far as advice on something like that?
That's a great question. Because another one that's similar, Dan, is sometimes you've probably seen this too. In bylaws, it says thou shalt have your annual meeting on the third Tuesday in January, and that often just doesn't work. You could have bad weather that day, and so okay, we missed it. We missed something by a few days in either example here. What do we do? I think it would be. I don't know that you necessarily have to restart your whole process. The question I'd have is, how did this impact somebody negatively? Because if you issue your notice 20 days out instead of 30, did you still issue proxies? Did folks still have enough time to get a proxy, even if they couldn't attend? Maybe if you had issued notice out 30 days in advance, some folks might have been able to save that on their calendar instead of 20 days out, but they'd still be able to turn in a proxy in all likelihood. So I just think that the odds that it's really prejudiced somebody in a negative way where they couldn't run for the board, they couldn't vote, is unlikely. So I don't know that you necessarily have to redo everything. I think it might behoove you, though, if you feel like, oh, we're not going to get quorum and we need to pass something, and we only gave 20 days notice instead of 30. You might rethink it in that context.
Okay. And where, I can't remember this question. Dick Reeder asked, and where do we get plats from if you want to request a plat for your neighborhood?
Yeah, plats are going to be found at the recorder's office as well. A lot of times, if you look at the instrument, the recorder instrument number on your declaration of covenants, the plat might be 1 digit less, because you usually have plat recorded and then your declaration of covenant is the very next document that's recorded. You can contact the recorder's office. They're pretty helpful over at Hamilton County's great, Marion County's great. I don't have a lot of familiarity with the other ones. I just went to Johnson County. They were great too. So just
Okay.
talk to the recorder's office.
Okay, Terry Hecht has a question. When covenants amendments are done per percentage of member approval requirements, does the approval require a document with the member's signature of the approval?
Yeah, that's another good question. It really depends on your governing document. Some will say you need 75% approval in an instrument signed by at least 75% of your owners. Others will just say you need 75% approval at a meeting. And so you'll want to be careful about, is there a signature requirement or not? And if there is, one thing that's hard to do if you've got a community of over 100 people is get 100 people to sign a document. And so what I often do is I'll have everybody sign a ballot, and then we'll attach the ballots to the recorded instrument to try to meet that signature requirement. So pay close attention to, is there a signature requirement on the actual instrument that gets recorded with the actual amendment instrument that gets recorded with the recorder's office or not?
Okay. Amy Woodall, I'm going to have to research that question. I don't understand that as much, but I'll get back. I'll look that up and try and figure out a little bit more on that if that's okay. TJ Johnson, going back a couple of slides, can a board decide on a restriction that is not stated in the covenants? Example, can't have any political signs up outside of the mandated Indiana law time frame is clearly stated in covenant. Can the board rule that political flags are the same as signs, even if no mention of flags in the covenant?
Yeah, I'd be concerned about any kind of substantive rule that is new. So it doesn't derive itself from anything that's already in your declaration of covenant. So let's say that let's keep it a little simpler. Let's say your governing documents have some kind of sign regulation, and it clearly says signs do not include flags. I don't think it's okay for your board to unilaterally impose a restriction that says, now we're going to regulate flags. I think you'd need to do an amendment in that context. I think that the question I often get is a flag a type of sign? And you'll remember one of my interpretation guides is we look at the ordinary meaning. You might find that the ordinary meaning of sign does include flags. I know sometimes I'll look at a local ordinance to see how do they define sign. And I think Marion County, I was looking the other day, they say signs include flags. So in your hypothetical, signs may already include the term flags. It'd be something to consider. In that way, the board doesn't have to pass a rule. It may already be baked into what's in your governing documents.
So the other one, Spencer, and this is a question that comes up a bunch. Can Indiana HOAs establish rules that have monetary fines to incentivize compliance?
Yeah, there is a 1987 Court of Appeals decision that put the kibosh on any HOA fines. So any punitive measure from a monetary perspective is not okay. Now, if the HOA goes out, incurs a cost, so you've got someone who didn't mow their lawn and it's, I don't know, it's 3 feet tall, and there's a provision that allows you to engage in self-help where the association hires a vendor to come on the lot to mow the lawn, and you incur a cost with that vendor, that may be something you can pass on. That's not a fine. A fine is, hey, your lawn's too tall. We're not doing anything about it, but you owe us $50 because it's too tall. That's not okay.
Okay, Ron, since attendance at our annual meetings is generally so low in most HOAs, and the meeting often requires a quorum, typically 50% of owners, how does the HOA board ever conduct an official meeting?
Yeah, in terms of conducting an official annual meeting, it doesn't. That's not, unless we meet quorum, it's not an official annual meeting. So a lot of so there's a statute that says the board stays on in that instance and can, under their governing documents, likely appoint any replacements. So what some boards do though is, okay, we didn't meet quorum, we don't have an official annual meeting, still hang out and treat it as what I call a town hall. So it's not an official meeting, and you might conduct an advisory vote of your members, the folks that did come, and just see a show of hands of who they would have voted for. And maybe you decide, okay, we're going to rely on that advisory vote and appoint folks to the board that everybody wanted. It's not a true meeting, but you can still conduct a town hall and have a discussion with everybody. I have some communities that they need to do more than just have a town hall. They need to pass actual measures and conduct a meeting. And so what I've seen are efforts to amend your governing documents to lower your quorum percentage down to 10%. And it can require, as I'm sure Dan's well aware, knocking on doors, trying your best to get proxies in order to amend your governing documents to lower quorum down to a reasonable figure. 50% is a lot.
And yeah, back to David Stahl's question, that is a lot of what we see difference. We'll see a lot of HOAs that have a lower quorum than condos. The condos, just because it's so much, they're dealing with a lot of different property and percentage of income and things like that. Those are generally 50% at least as far as quorum, just because they want to make sure everybody's got a vote, and condominiums are usually a little bit smaller. So Sheldon has a question. I think it's our last question for the day. We do motions and voting through emails now. Should they be read into minutes at person in the meeting?
I think I'm going to have to make some assumptions about what we're talking about here. I think this is probably talking about where boards, they decide to take various actions or vote on matters via email, or vote on motions via email. Very typical, rather than get everybody together for a board meeting. The key thing under the nonprofit code is if you're going to take a board action outside of a board meeting, so you're going to do it by email, all members of the board of directors have to consent to that. The board has to be unanimous over email. And then what you do is you want to keep those emails or that vote together and keep it with your minutes or your corporate records in some form or fashion. You just want to have a record of those votes, that unanimous vote of all of your directors.
Yeah, I think Sheldon, before COVID, we were not big fans of that. It just really didn't seem like something that worked well for Kirkpatrick as far as trying to get everybody to vote on something and agree on something via email. Large a condominium down in Jeffersonville, they're never going to get 100% voting behind something or 100% approval behind something. So everything usually has to go to, at that point, you don't need 100% at a meeting, but you do need 100% over email. At a meeting, it just needs to be majority. So that's where that comes in a lot. And I think that's all the questions. Stephen, I don't understand Amy's question, Amy Woodall's question. I'll read it to you just in case maybe you do. It's a little bit further up. Unless you understand that one, I might try and answer that one offline.
Yeah, that one's.
So I guess basically, if you get somebody out of a pool 1 year for trespassing or for the reasons, do they get a free next year? Do you have to reissue it?
Yeah, I think that probably gets a little bit more into the criminal code realm of what a trespass notice does. I think probably what the trespass notice says controls in that context, and I don't. And also, I guess I'd want to know what our governing documents say about member suspensions too, because sometimes the suspensions, I mean, how long does it last? Some might just say you're suspended for 60 days. Because in this instance, I don't know what the conduct was that necessitated this, and whether this homeowner could cure what they did wrong. I think that one might be a better question for whoever issued the trespass notice, perhaps. I'd probably need a little more context, Dan, to weigh in. Those are just some kind
Amy,
of
I'll get back to you. I'll get with your manager and get back to you and get you hopefully a little better answer on that, and down the line. Okay, I think that is it for us. Thank you all for sticking around. Thank you, Stephen. Thank you, Kelly and Alyssa, for putting this together. And all of you, if there's anything we can do, okay, there we go. Can we get copies of the slides today? And yes, I don't know if you get copies of the slides today, Stephen, is that something you can do, or is there anything proprietary of the slides? If we usually do send the PDFs if we can, the slides.
Yeah, Dan, I don't have an issue. If folks want PDF of my slides, that's fine. Okay. I think I sent those to you earlier today, and I didn't make any changes. So
okay, so yeah, we'll send those out. Alyssa will have those on there, and yeah. So Amy did say she had done a verbal suspension, then a verbal warning, then a suspension of the pass for 60 days. So there you go on that.
Yeah, probably in that context, maybe if the suspension's over, they may be reissued a pass, but I don't know how that would impact a criminal trespass notice. That might be something else that has to be dealt with by that particular homeowner in the criminal context, so.
Okay. All right. I appreciate everybody's time. Thank you all for coming out today, and we will get back to you. There's another one coming up. I believe there's one coming, Kelly, there's one in September. Is that correct?
That is correct. There is another one, I believe it is September 8th, which will be covering budgets and reserve studies. And we will be adding another roundtable event in the fall as well with those details to come.
Okay, thank you very much. Thank you all for your time, and I appreciate everything, and we will see you all next time. Enjoy your day. It's a beautiful day out here. Enjoy it. Thank you.
Thanks, everybody. Thanks, Dan.
Thank you.
Thank you.